Another question, what if the building that's all the units in it and is in foreclosure? Then what are the legal responsibilities of the landlord to notify the tenant? How is that handled?
Okay, so the question is, what are the landlord's responsibility if the building is in foreclosure? So that's kind of a broad question, right?
Well,
And so the issue becomes if the tenant is paying rent, right? And then what is the landlord's obligation after that? You have the issue between the landlord and tenant, and I don't think that that issue in and of itself is going to protect the tenant from any actions that the secured creditor is going to have in recovering their property. So if you have a situation where tenant is paying landlord is not paying the bank, the bank comes in and forecloses, the bank has the right to, after following certain requirements, to recover possession of the property potentially. In certain circumstances, they have to continue to honor the lease, but in other circumstances, they can get the property back. And so it's going to kind of be based upon the individual circumstance.
yeah.
That would, yeah. I mean, I don't see why those exemptions would not apply even with the creditor coming in. And I know that's been argued in the past. I know that was an issue, but I don't think that the creditor comes in any different position than the actual landlord.
Well, because at that point they're the owner, right?
That's
After after the
exactly.
foreclosure is done.
Yeah, they kind of step into the shoes,
Yeah.
right, of the landlord at that point in time.
Yeah. Right. Next slide.
Oh.
That's your
This is my
slide.
slide. Okay. Oh yeah.
Oh.
No, I've had documents rejected. What I've provided is, payday lending receipts where the owner is borrowing money to try to make things, filing their social security statements showing their $1,200 a month is all their income that they get. And the mortgage statements that they've got to pay and these things. And I'm trying to file those under C, and they get rejected. So I think that at some point we need to, because I'm trying to use the sealed financial that you use in a divorce, right? Trying to use that same mechanism, but they just get kicked back and say, no, we can't. We can't file these sealed documents. And I think we need to kind of address that because they are essentially opening themselves up. I mean, there are these people that just their only income is Social Security plus $800 in rent. That's another losing homes, and so we got to prove that by the preponderance of under significant hardship. But the inability to file things under seal is causing problems.
So
that's all I have to say.
Yeah. So the comment was made with regarding on the landlord side proving under significant hardship. Councilor has talked about issues he's had where he's tried to prove financial hardship on the part of the landlord, that their current income doesn't provide sufficient income by itself to cover the mortgage of the rental property. And he wants to be able to file their income records in the eviction file under seal to show that they're suffering a significant financial hardship, and use that as a basis, as an exemption. And he hasn't been successful in doing that. It might.
Winning. I've been unsuccessful in filing things under seal.
Yeah.
Because
I see.
want to file bank records under seal.
Gotcha. And so,
under seal. And
understood. So to clarify, he says he's prevailed on those arguments, but he has had to file the income records
in
the open file, so they're public access. Might be worth maybe doing a preliminary motion, maybe see if you can get an order sealing just that portion, just sealing those records from the commissioner.
Well, we also have no idea how to do it because
you'll be
the language we've got. What does it mean? How do you prove it?
Yeah.
I mean, I'm doing financial declarations. I'm doing all that.
Yeah.
Right?
But
just pull them up with family law and try to show they're broke. Right?
Right.
Here's my expenses. Here's my money.
Yeah, but specifically with regard to getting those specific records sealed, might be worth bringing up preliminary motion just for that purpose.
Or if this is the law, maybe talk to the commissioners and have them open up for an ability to do it.
Yeah, if I would say, that the clerk's office potentially could help with that.
That's
I
just
think,
a concern. I just wanted to bring it up because it's frustrating, right? You know,
Yeah.
you're giving your bank records for the last 3 months, right? And normally they'd be under seal in any other litigation, right?
Mhm.
But
Sure.
not here, it's not allowed.
Well,
That's all
I mean,
just gonna leave it at that.
I don't think so the question again is, the inability to file with the clerk, the sealed financial source documents, for example, using the same cover sheet that's available in family law. And I think that is something that could be addressed at the clerk's office level, but I also think that you could perhaps ask for an order, right? You might have to do the bone club analysis, right? And pull the court. Or if I were in that position, I might file it as using the notice cover sheet and then just redact kind of, everything but the last four, anything highly
That's what
sensitive.
I
Yeah.
redact the proof on. People
Yeah.
still don't like their bank records in there, but,
Yeah.
and they don't want their social security records in
Yeah.
there, and they don't want those, so you do your best. But, okay,
Right.
thank you.
Next one. That's your slide.
Oh, yeah, okay. And so I just wanted to throw a slide in there just to kind of cover some of the basic, some basic practice tips. So on the landlord side, when you do your eviction action for evictions in the Tacoma city limits, again, make sure that that you at least reference the Tacoma business license number in your complaint. I know a lot of landlords like to keep their initial pleadings if someone's a complaint as streamlined as possible, and then they'll add in the other evidence later. But I'm a big fan of, for the Tacoma evictions, just attach a copy of the license as an exhibit to the complaint. I also like to have a statement in the complaint regarding compliance regarding the student or school year exemption. So just because commissioners like to see that, so it doesn't hurt in your complaint to have your client, confirm that that exemption does not apply to this particular eviction, that the school year eviction does not apply to the case at hand. Another situation is if the rental property has a Tacoma address, but it's not in the Tacoma city limits. Again, we don't want to throw the commissioner for a loop. So go ahead, if you do a search for a Tacoma address lookup, if you Google that, it pulls up a page that the city of Tacoma hosts. You can input the address, and if the address is not in the Tacoma city limits, it'll pop up a map, show you where the property is relative to the Tacoma city limits, and it'll say not in the Tacoma city limits. Take a screenshot of that and attach it as an exhibit to your complaint. And again, we're just trying to keep things as easy as possible for the commissioner, because when they see an eviction come in front of them at the show cause hearing as a Tacoma address, they're going to be thinking of these three things. Is there a license? Is there kids, school kids involved? Is it actually in the Tacoma city limits? And if you can answer those coming out of the gate, then they're not going to be distracted when you have to argue the real issues at hand at that show cause hearing. Let's see. Oh, and talking about show cause hearings. So under the Fairness Code, you are required to have a show cause hearing if the rental property is in the Tacoma city limits. So there's no defaults allowed on that eviction action. So just be prepared for that. They cannot be evicted without a court hearing. And let me just take a quick look if I can reference them. Okay, no, thought I had it at my fingertips, but I don't. So the show cause hearing is required. Because of that, you don't know whether or not your tenant is going to appear at the show cause hearing or not. And so again, to aid the commissioners, I know particularly recently Commissioner Farmer has requested that the DMDC certificate be filed. And so if you're not familiar with that, you can go ahead and I've left the link there. You have to go online, file, and you put in the tenant's name and their birth date, and it'll kick back a report immediately as to whether or not that tenant is active duty military, right? And so it's just a sacred compliance requirement. We don't want to be defaulting anyone who is active duty military. So include that in your evidence going to show cause, and you're going to make life a lot easier for the commissioner. The last thing is, if your tenant does have any of these exemptions, whether it's a cold weather exemption, the school year eviction, or any other exemptions they may be entitled to, on your order issuing the writ, you want to strike the forthwith language, which is typically there in any boilerplate form. So you need to strike that because they're not going to be issuing the writ forthwith. They'll be issuing it whenever the exemption period is run. So you'd strike the forthwith language. And if it's a cold weather eviction, you would substitute that with April 2. If it's a school year exemption, you would put in the day after the last day of the school year. You need to take a look at that. That information is available online. Look at the Tacoma Public School District school year, but it's subject to snow days and those types of things too. So you need to make sure you include that.
Next one.